You're watching To The Point. I'm Preeti Choudhary. I want to completely now cut across to Pinky Anand, Senior Advocate and former ASG, on her perspective on what we are witnessing right now. Ms. Anand, appreciate you taking the time out this evening and joining us on To The Point. Now, my first question is a question that many people right now are asking in the country. We've seen one lower court after the other take up, many would suggest, a very sensitive, contentious issue of places of worship. Is it in any which way? We've seen the Varanasi Sessions Court do it. We've seen a lower court in Mathura do it today. Is it in any sense violation of the Places of Worship Act 1991?
The first question, Preeti, that I would respond to you on is the fact whether the Places of Worship Act itself is constitutional or not. The second issue which I think I have in mind is the fact that whether to the Kashi temple itself and the site in question, does the Ancient Archaeological Act of 1958 apply, or is it the Places of Worship Act? So I think if you look at these two questions, there will be a major difficulty, because ultimately this act was passed in 1991, of course at a time of huge crisis. Despite the fact that it was so controversial, it was not sent to a select committee. It bars judicial review, so you ultimately do not have any recourse, and on that ground alone, one of the major challenges to the act would survive in its own way. So the finding of trial courts is one part of it, but the Supreme Court itself has entertained the petition whereby the same subject matters have been challenged of the Places of Worship Act 1991, and the fact that the Supreme Court has entertained the petition itself is indicative of the fact that there is some substance to the argument that the act itself is unconstitutional, and of course, as I said, the second part of it, whether the act itself applies or not, is a moot question.
Now, we'll come to the Ayodhya judgment as well, but now you bring up the Supreme Court. But the other question, which, because it's of high interest to a lot of citizens in this country, especially the fact that the Supreme Court has, gone ahead with what the Sessions Court said to seal the area where the, claimed shivling has been found. Is this a way that the Supreme Court has accepted that there is a shivling? Or it's gone ahead and accepted the order of the Sessions Court by sealing it?
You're right. I mean, ultimately the Supreme Court has found some substance by protecting the shivling area in question. What was the purpose otherwise of protecting that area? And of course, at the same time, for other directions as far as the prayers were concerned, but the protection of the site area in question, which is somewhat of the disputed area, and of course some of the reports that have come out are indicative of the fact that there is enough evidence possibly, and incidentally Babri Masjid, the case also was based upon the fact that there seems to be enough evidence to indicate that there is a shivling, a lotus, a trishul, carvings, and all those issues. Of course, some of those are not substantiated so far. These are news reports that have come out. But the fact that the Supreme Court has protected definitely indicates that there is some substance to the argument that the shivling was there and the temple existed, which seems to be historical accuracy, which cannot be disputed.
Ma'am, legally, do you see this go exactly the way as the Babri, what happened after Babri, then the Ayodhya land dispute? Is it going exactly the same way? Of course, there is no demolition of the structure, but legally speaking?
Well, Preeti, there are a number of similarities definitely to the issues in question. I mean, there is partial demolition here, partial which happened during the time of Aurangzeb and whatever the history records it. And definitely there are disputed sections which are claiming the privilege of the area of worship in question. So one, of course, the petitioners who had filed the petition in the first place, seeking the opportunity to give prayers at the shivling and to enter that area, and the other, of course, the Muslim segment, which is claiming its rights to continue with the mosque and not to have any intervention at that stage. So this is exactly somewhere where the Babri Masjid also headed, with three disputing contestants as far as the issue is concerned. How it would go, I'm afraid I would find it impossible to predict. Right. But I can say, and again the evidence part of it. For example, the evidence that came out in Babri Masjid itself was indicative of the fact of the rights of the temple and the deity to have continuation of worship in that area. Similar appears to be forthcoming in the present matter. Of course, we will know in due course, because the Special Commissioner also has submitted the report. The report has not been made public, I repeat, but whatever one has seen from the indications and of the course of the Supreme Court also passing an order appears to indicate that there is no ambiguity whatsoever. It is certain that a Shivling did exist. However, the determination and the adjudication process will of course go on and decide the ultimate issues in hand. Whether it goes exactly the same way as the Babri Masjid went, in the sense that the Hindus were given another site to build a temple and to offer their worships there, and that is the manner in which the issue was held, I cannot say, but well, there are always reasonable possibilities. You have a large bench, constitution bench, which ultimately rendered the judgment, which has been enforced, and we've seen those times. It came out of Lucknow and finally landed up in the Supreme Court, and all the legal arguments having been considered, it was ultimately held that everybody's rights should be protected, and that is the manner in which the Babri Masjid judgment went. This judgment, we will see how it will run in the course of time. There are some other issues involved, including the Places of Worship Act and the application and the Ancient Archaeological Act of 1958. So we will have to let the law takes its own course. You know,
Ms. Anand, the fact is, let's put aside the Places of Worship Act 1991. I want to, because there's a lot which has been written and lot, which has gone down in print when it comes down to the 5-judge bench Ayodhya judgment. Now, it's a landmark verdict. I would reckon every Places of Worship, which is going to face a dispute will go back, and the judge would refer to the Ayodhya bench verdict. And when you read through that, and there's so much written, it essentially seems to, lay down the law for the future, where it says non-retrogression is a legislative instrument designed to protect the secular features of the Indian polity, which is the basic feature of the Constitution. Will this also be an issue going ahead, this particular judgment, the Ayodhya judgment?
Of course, the Ayodhya judgment is extremely relevant for purposes of determination, and it is something that would be looked at, considered, pondered over, and ultimately analyzed in order to see how the same would apply in the facts and circumstances of the present case. It can never be said that it will not be. The extent of the application, however, would vary upon what emerges from the reports, what emerges from the application of the Places of Public Worship Act, as I said, and whether it applies there or not. You do know that one of the arguments which is made is that this act was never intended to apply to the Kashi temple and the Shringar temple also. So these are some of the arguments which will have to be considered, but be that as it may, the factum of its relevance, the Babri Masjid judgment and the Ayodhya judgment, would definitely be predominant in consideration of this case.
Would you, constitutionally, because it seems to be a conundrum for, you're the better judge of that, but would you think the safest route, or if the government really wants to go ahead, because now the government is speaking, just the safest constitutional route, because there is majority where the Lok Sabha and Rajya Sabha is concerned, that the government, if it wants to go ahead with what is happening in Varanasi, what's now starting in Mathura, to go ahead and scrap the Places of Worship Act 1991. Would you think that would be the best way to go about it?
I don't like to step into the shoes of people who are to decide and the senior people who are to decide, but I can say this, that indeed when the act came into being, it came into being at the Narasimha Rao government, indeed at a time when the Ayodhya dispute was at its peak, and indeed it was brought in obviously and so-called, let's put it like this, vested interests. So if the government indeed feels that it doesn't fulfill a constitutional objective, if the government feels that ultimately it doesn't have an adjudicatory mechanism and therefore suffers from arbitrariness and unconstitutionality, and the Vairis themselves are in issue, it is of course always open to the government, and the government should consider such an option, because it did come under protest and without any consideration, without any deliberation, without any reference to the select committee, and therefore I think it definitely requires a relook.
On the 13th, Ms. Anand, 13th of March 2021, the Supreme Court had asked the centre to respond to a plea challenging the Places of Worship Act. The centre is yet to file a reply on that. Would you think that, this shows that the government possibly is reluctant to disclose its cards, or it's the legal cause?
It's a legal course. I mean, government takes some time to consider, ponder, decide what stand it is to take, and we've done that enough times. I appreciate, and in fact, it's a very well considered aspect. If there is no immediate response to a petition, rather there is a well thought out and reasoned response by the government, which shows that the government is applying its full mind to the issue in hand, and what needs to be really considered is whether the act itself is constitutional or not constitutional. Thereafter, it is in any case for the court to decide that if it is unconstitutional, the same has to be struck down. The other option is for the government to consider and to strike down the law and to repeal the law if it so feels.
Will it be legally considered, ma'am, that because of what is going down right now, we are standing at the precipice of opening up a Pandora's box of, if we give legal sanctity to what is happening in Gyanvapi, what's today has happened in Mathura, that it could just blow up because there are already multiple petitions in multiple courts?
I'm afraid when there is a disputed issue such as this, and it affects lakhs of people, and the question of ultimately faith and the freedom to practice religion, of course, which is a constitutional right, whether a spate of petitions comes or not, whether it opens a Pandora's box, I don't think we have to look at the net, what is to come out of that precipice or to be at the precipice. What you are looking at is the issue has to be resolved. So the Supreme Court is in any case seized of the matter. The issues would substantially be somewhere wavering around this, this broad issue, and so ultimately a decision has to be taken. Having a panoply of, let's say, petitions coming up before the Supreme Court or other courts is not really the main target. The question is it right or is it wrong?
Ms. Anand, I'll ask you just two more questions. The fact that now there is clearly plausible evidence which might be sealed, but the lips of the commissioner weren't, so he's gone ahead and given all these interviews. So we do know that there's plausible physical evidence of Hindu relics inside the temple. Now that all of this is as evidence submitted, what happens legally? What do we see? What's going to be the conundrum that possibly the Supreme Court will face tomorrow?
I think, Preeti, we've already gone through some of that, but let me just repeat some part of it which addresses your question. To say this, that what is before the Supreme Court and what will be argued, I assume, is the fact of the relevance or the constitutionality of the Act itself, the application of the Act to the Kashi temple and the site in question. The question ultimately would revolve around these issues, and definitely the evidence that is collected and which appears to have come, as you rightly said, it appears to have come forth that there is a shivling and there is enough evidence to indicate that a temple did exist. So therefore, it has to be considered in that backdrop. But in the meantime, whether the Act itself will sustain itself, if it doesn't, then the question of giving the Hindus the right to worship the shivling in the area in question can hardly be a disputed issue.
Mama, last question, which really doesn't have much to do with the case, but there is a lot of questions, like I said, because it's caught the nation's imagination, is the two-judge bench that is hearing this petition. One of the judges was a part of the Ayodhya judge, the five-judge bench. The other one was a lawyer for the Hindu side at one point of time. Does that in any which way come into play? Because we're getting a lot of questions being asked on that as well.
I think we have to trust the fact that the judges who are hearing the matter, if they were part of the Constitution bench, they definitely took a view in the facts and circumstances of that case, and there is no question of there being any questions asked on that account. We do have full faith in the judicial consideration of the issue in hand, and even if there were judges in the Constitution bench itself, would make no difference. On the contrary, it is something which has to be considered in any event. So I don't think any focus could be put on that kind of issue or perspective.
Ms. Pinky Anand, appreciate you taking the time out. Thank you for joining us. A lot of people have a lot of legal questions and all the rhetoric that is going down. Thank you for joining us this evening, Ms. Anand.